Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I know there's a lot of background, but that's the nature of Coffee Talk. And so let me tell you what I'd like to go over today, what I'd like this video to be on. In this particular case, I'd like to talk a little bit about capacity, and there'll be several more videos in detail as time goes on, but in this particular case, I'd like to talk about it in general and how it can affect the making of a living trust or basically the tearing apart of it. So, when someone makes a living trust, whether they don't go to a lawyer, whether they do it themselves, whether they get help, whatever it happens to be, um, they have to have the capacity in which to make the trust. And for all intents and purposes, because you're probably saying, well, what exactly is capacity? What's incapacity? For all intents and purposes, they have to understand what it is that they're entering into. It cannot be with undue influence, fraud, duress, or mistake as part of making the trust. Like for example, I give a couple examples that clearly would show they're never this clear. But just to illustrate the point, let's say that you have a son-in-law that wants to have your house when you die, okay, and comes to your house and puts a gun to your head and says, you are to sign this document bequeathing the house to me when you die, or else I will shoot you dead. Okay, in that particular case, that would fall under duress. Okay, clearly that particular living trust would be set aside because of it. Or another example, let's say that you're sloppy drunk one night and your sister comes in and says, hey, if you sign this particular document, that will mean you will not get a DUI and you won't get a conviction. Everything will be fine. And you go, okay, great. And you sign the document. And in effect, what she had you do was sign a living trust bequeathing all you do. Okay. In that particular case, again, this would be fall under mistake. Okay, you didn't know what you were signing, and therefore that would be set aside as well. And again, as I said, there was fraud. So, somebody could, one of your family members could come up to you and tell you that your great uncle has, agreed to give $1 million to you if you will agree to bequeath, houses A and B to whoever is talking to you. And let's say that wasn't true. Okay, well, clearly that would be fraud. Okay, so those are crystal clear, blatant examples. Again, they're not usually that clear, but it gives you an idea that just because your signature is on a living trust, that by itself doesn't mean that the trust will never be attacked, that it'll never be in court, that it'll never be fought. So you want to make sure that when you're doing the living trust, again, with an attorney or without, that none of these factors exist, that you have sufficient mental capabilities to know exactly what you're doing, to know what you're signing. I mean, obviously, another factor is that you have to have the mental capacity to understand what you're doing. So, even if there's not the grounds to set it aside, as I just mentioned, let's say you have dementia, okay, and you can't remember your children's names. Again, giving clear, obvious examples just to make the point. But in that particular case, you'd be able to, or somebody would be able to trust as well. And so, all of these reasons lead to the understanding that, basically you should do a living trust when you're young, when you have all your faculties with you, meaning you have your mental capabilities, when you're not in a position where you have to go, oh my God, I have to make something right away. Like let's say you're married and your spouse gets in a bad accident and you think, oh my God, I don't even have anything prepared, and you quickly whip together a living trust. It shouldn't be like that. It should be when everybody's healthy, when everybody's working, when everybody knows what they're doing. Okay, that would be the living trust, which would be much more difficult to be set aside because the reality is somebody somewhere might want to, fight this. They might say, "Well, he meant to give this to me or that to me, and he just didn't put it in there, or he didn't lack the capacity." So you want to make sure that you can try to avoid that, and that everything is done correctly. Because if a living trust isn't done correctly, and there's no statements or issues in there regarding competency, it might be an issue. So make sure that you see an attorney who knows what they're doing, that you are in a situation where you have all your mental capabilities, you're not delusional, you're not hallucinating, you're not under duress, nobody's forcing you to do anything, and that you are reviewing living trust and everything at your own leisure, and not doing it within a 3 minute time period where somebody says, "Here, just hurry and read and then sign here," type thing. Um, Also, an interesting fact is, there's two kinds, well, there's more, but there's two primary kinds of living trusts. One is revocable and one's irrevocable. The revocable one means terminate it anytime. And because of that, the burden of proof to show whether you lack or don't lack capacity is less. If it's irrevocable, it means you can't change it. There's nothing you can do. And so then the burden would be a lot higher, because in that particular case, if it's irrevocable, obviously, and you can't change it, they need to make doubly sure that you had the capacity. So the bottom line here is that if somebody comes into my office, of course, and they want to do a living trust, I make sure that they have sufficient capacity and they're not under any of the factors that would get it set aside. So people come into my trust who are just a living trust that was made years ago by somebody, either maybe an attorney who didn't know what they were doing, or they did it themselves, or they printed a form off the computer and without understanding really what they were signing. And then I look and I possibilities, the capacity or incapacity, and if so, then we can get the trust set aside, or the provision of the trust set aside that deals with that particular issue. Okay, so if you like the video, click like, subscribe, and then also feel free to give my office a call. We have offices in Los Angeles and Long Beach, so if you live in those areas, we're easy for you to get and see me. Consultation's free, and it'll put yourself and your family, give you peace of mind if the living trust is done properly. Okay, more in the coming videos.